Welcome. This program is entitled The Bar Examination, Attorney Admissions in the Pandemic, a conversation about employment issues for new law graduates in 2020. This program is sponsored by the City Bar of New York, and we're happy to be joining today a conversation about how the pandemic has impacted particularly bar exam administration and admission to the bar for thousands of law graduates across the country. Obviously, the pandemic has caused unprecedented disruption to all aspects of American life, and legal education is no exception. There's a great deal of uncertainty at the moment around the bar exam and attorney admissions around the nation, and we hope to be able to shed some light on how those matters are evolving this afternoon and take your questions as you share them with us. And we have a great panel. And at this time, I'm going to ask each of the panelists to just introduce themselves and say just a bit about their background and perspective. So why don't we just go alphabetically and begin with Mary Lou Billick.
Thanks, Craig. Hi, I'm Mary Lou Billick. I'm the Dean of Community Law School, whose mission is to create access to legal education and create excellent social justice lawyers. For purposes of this panel, I guess my short bio would be that in 1985, I was the secretary of a city bar committee that called for a serious examination of the bar exam, wondering whether and how it was related to competent practice as opposed to recovered knowledge under high stakes circumstances about the law. But since that's not going to be the question posed to me, I'm going to try to just be descriptive in answering my question. I'm really pleased to be here today.
All right, thank you. Hank Greenberg.
Thank you, Dean. I am the immediate past president of the New York State Bar Association. I stepped down a couple of weeks ago when my term ended. I'm a partner with the law firm of Greenberg, primarily doing litigation, and I recently became the chair of the newly formed state commission. Chief Judge DiFiore created it to reimagine the future of New York courts.
All right, great. Glad to have you. Anne Lefevre.
Thank you. I'm also very pleased to be joining the panel today. I'm a partner in the litigation group at Pillsbury Winthrop, and I've been there since, started as a first year in 2007, so I can tell you, somebody who started her career right before the Lehman Brothers crash, and starting her career during a time period of great uncertainty, I really empathize with the class of 2020. And I also serve as the hiring partner for the New York office of Pillsbury Winthrop, a position that I've had for 3 years now. And so and prior to that, serving on the recruiting committee for about 6 years.
Thank you, Anne. Good to have you. Deborah Jones-Merritt.
Hi, thank you, Craig. I too am very happy to be here. I am the daughter of a professor who taught at a law school located in New York for most of his lifetime. And I also graduated from a school located in the great state of New York, so I feel great ties to you. I'm currently a distinguished university professor at The Ohio State University. I do a lot of my research on licensing and the competencies that lawyers need, including having just finished up a study that involved 50 focus groups in 14 states, rural, urban, all sorts of input about what it is that new lawyers really need to know and be able to do. I might drop a few hints about the results of that study, which won't be out until December. I co-authored a policy paper this summer with Mary Lou and some others about options for states, and we jointly maintain a website called barcovid19.org that continues to update people on those options.
Thank you, Deborah. Good to have you here. My name is Craig Boyce, and I'm the Dean of Syracuse University College of Law. And I've been here 4 years. Prior to that, I was a Dean at Cleveland Marshall College of Law for 5 years. It's very difficult to be a dean and not be deeply engaged in issues around the bar and around licensing of new lawyers. And so this is certainly a topic that's very near and dear to my heart. So our format will be that I will ask a question of each of the panelists as an initial matter, and they will spend several minutes sort of responding to that question. And then we will turn to the Q&A and get questions from the audience. You may ask questions by hitting the Q&A button at the bottom of your screen and then typing that in. I will monitor those questions and share those questions with the panelists. So if we can just step back a few months, COVID-19 strikes in March, as most of us were in the middle of our spring semester. By April, virtually every law school in the country had closed to in-person instruction and was providing distance remote instruction so that people could be in lockdown, quarantine, to promote safety around this virus. I recall a great deal of uncertainty about how long it was going to last, what things we would need to cancel, whether we could continue to do things. It became clear as infection rates grew that events a couple of months out were clearly going to have to be canceled or postponed, and that happened. One of the biggest for all graduates of law schools is the bar exam, which happens in July and February of each year. The largest administration of the exam is in July, and the uncertainty there created a great deal of concern among my students and among students across the country. Bar exam boards, the National Council of Bar Examiners, state courts all began to look at this problem. They were confronted with really not a lot of good options. They could delay the bar, simply cancel the one in July and wait till the one that rolled around in February. They could delay the bar and offer an interim bar later in the fall as they were able to ramp up to that. Of course, that presented problems of capacity because with social distancing and the need for personal protective equipment, it was going to be challenging to be able to administer the bar to all of those who wanted to take it. This would be a particular problem if the bar was canceled in July and simply put off to February. You'd have even more people wanting to take the bar then. And so capacity has been a central issue. Some states have looked at spreading students, graduates out as they take the exam and offering or administering the exam in a number of locations. Of course, there's not enough capacity, and so then that led to questions of who's going to be able to take the bar exam. Will we limit it to those who are taking it for the first time? Will we exclude LLMs? And so that has caused a great deal of concern about equity as well. Is it safe for students to travel around the country to the different states where they want to take the bar exam? Are there some sorts of measures that should be taken to protect bar takers from one another if they're coming from highly infected areas and so forth? Do we simply waive the bar exam this year and provide for some alternative way for graduates to be admitted to practice, perhaps practice orders, perhaps a different kind of exam, maybe an online exam? So these are all the things that are sort of swirling in the air at the moment. And I will begin by asking the first question of Deborah Jones-Merritt. Debbie, obviously, huge impact from COVID-19 on how the bar exam and the bar process will work in 2020 and the ability of our law graduates to practice law. I know that you've done a lot of work in summarizing and maintaining an updated index of things that different states are doing. Can you share how the different states have responded to the pandemic?
I'd be happy to, and let me share my screen. I think that works there. Since I'm going to be talking about a few numbers, I thought I'd throw up a PowerPoint slide or two. Before we talk about what states are doing, for those of you in the audience who are not complete bar exam nerds, I need to give you just a little bit of background about what is available for the bar exam. The National Conference of Bar Examiners, known as NCBE, prepares many of the materials that states use. Many states use all of the NCBE materials, and all except Louisiana use at least some. What NCBE prepares are a set of multiple choice questions, a set of essay questions, and also two performance tests, which are closed case files that test takers are given to read, to analyze, and then to prepare some sort of written document, maybe a memo to a partner or a letter to a client or even a complaint. So those are the materials that NCBE controls. And what they have decided this year is that they will make all of those materials available on 3 sets of dates, the originally scheduled date in July, plus 2 dates in September. Recently, just a few days ago, they also announced that they will provide a half of their materials in October, early October. This will be for online administration. The first 3 opportunities are solely for in-person. States cannot use those NCBE materials and put them online. But in this early October session, they will provide half the number of multiple choice questions, half the number of essays, and half the performance tests for a 6-hour bar exam rather than a 12-hour one. And we'll talk in a few minutes about what kind of impact that might have. Let's look though first at what states are doing now that we know what materials they have from NCBE. Well, 20 of them have decided to go ahead with the in-person exam in July. 17 are going to give an in-person exam on one of those 2 September dates. And 5 have decided to offer the in-person exam in both July and September as a way of spreading out test takers and also as a possible hedge if they're not able to give the exam on those dates. Now, before we go on and talk about the other approaches states are taking, what are the advantages and disadvantages of these approaches? Well, one advantage is that this sticks as closely as possible to the status quo, which is comforting to a lot of people, both to test takers and to bar examiners, and perhaps also to some employers. And also, at least from the time that states made these decisions, which was back now in April and early May, it provided some certainty to test takers. They knew that they could go ahead and they could begin studying for this regular bar exam that was quite familiar to people. The disadvantages, unfortunately, are now growing with these approaches. One is that it's becoming increasingly clear that these exams will still be dangerous. In fact, and this is something we don't talk about quite enough, they will probably be more dangerous to the staff overseeing the exam, the support people who are cleaning and otherwise working in the building, and the community that hosts the exam, rather than the test takers themselves. That's because of the number of people that some of those will be exposed to and the types of exposures that they will suffer. Because of those disadvantages and the fact that the virus is actually increasing in many states now, at least some of these states, maybe even many of them, will end up canceling these exams, perhaps even at the last minute. That is going to be potentially expensive for the states if they have binding contracts with the arenas and other places they plan to offer the exam. It's going to be devastating for test takers who will have spent 10 to 12 weeks preparing for these exams and then are not able to take them. And it's also going to create a hole in legal services in those states, especially for employers who serve low income and other disadvantaged people, because they rely very heavily on new lawyers to do their work. And these new lawyers won't become available until sometime in 2021. This approach also overlooks some rather extraordinary circumstances affecting this year's test takers, circumstances that have actually changed quite a bit even since states made these decisions back in April and May. We are seeing even more and more the psychological and practical challenges of this pandemic, about how difficult it is for test takers to study, how challenged all of us are feeling after so many months in lockdown and limited social contact. Now we, of course, are facing ongoing murders of Black men and women, compounded by police violence towards peaceful protesters. This is creating enormous emotional turmoil in many of our test takers, actually approaching secondary post-traumatic stress disorder in some, especially those who are Black or other candidates of color. And while it's true that lawyers must learn to operate in stressful conditions, we have a stressful profession, we have to remember that the bar exam is designed as a uniform measure of minimum competence that is administered each year under what are supposed to be standardized conditions. It is scored based on the assumption of those standardized conditions. The conditions this summer simply are not standard. They are very far from standard, and when we administer these exams, the scores are going to fall. That is inevitable. So we have to think in these states whether we're ready to fail a record number of examinees, not because they came to law school with lower LSAT scores or because their preparation wasn't as good, but simply because of the circumstances of this summer and the fact that this summer differs so greatly from each of the last 40 summers. Now, responding in part to some of these concerns, a few states are doing something different. 4 are developing their own online exams that they will offer in July. Most of these, or I'm sorry, 2 of these will be all essay exams in Michigan and Nevada. The Nevada one will actually be open book, which Nevada is doing in part to avoid security issues with test takers online, and in part is one of the, as the Supreme Court said in its order, because this actually parallels what we do in practice in any event. Washington recently decided to offer a diploma privilege that will be available to any graduate of any ABA accredited law school who had already registered for the Washington bar exam. So people can't flock to Washington to become Washington lawyers and then hope to transfer elsewhere. Utah has taken perhaps the most complicated approach. It is offering a limited diploma privilege, which applies only to graduates of law schools that have first-time bar pass rates of 86% or better. That's a measure by law school, not by the individual. And then in addition to presenting that diploma, the individuals have to engage in 360 hours of supervised practice. 2 jurisdictions, Maryland and DC, have decided to use the NCBE's online exam. And then finally, we have California, which is still undecided. They have postponed the exam until the fall, and they are favoring an online exam, but they haven't decided yet whether or not they will be able to do that. Now, what are some of the pros and cons of these approaches? A pro is that all of these protect the health of the test takers and the community better than in-person exams. They also, at this point, offer more certainty than the conventional exam because none of these are subject to being canceled, or they're very unlikely to be canceled between now and when the scheduled dates are. They also partially respond to the extraordinary stresses of this summer in the way that they've reconfigured the exam. And at least the first 3 offer as much assurance of minimum competence as the traditional bar exam. Now, that may sound puzzling, or you may wonder about that. That is based in part on my long research in this area. The current bar exam has never been validated with respect to law practice. We know that it correlates to law school performance, but we don't know that either law school performance or the bar exam correspond to minimum competence in practice. Studies on this issue are underway. I am, as I said, directing one of them, and I have all of the data. The results suggest that the current exam is mediocre at best in predicting minimum competence to practice law, and that these alternatives would not be worse. In fact, some of them would probably be better in terms of detecting minimum competence. The half a UBE, oddly, is the outlier here. It sounds most like the regular exam, but a half exam is quite problematic. You have to think about the fact that these candidates will write only 3 essays and do 1 performance test. And are people really comfortable with that being a measure of their writing and analytic ability? The test may also turn out to be more stressful for the test takers because on a high stakes exam like this, they still have to study and memorize all of the legal principles that are tested, but they will have half the chance to show what they know. And that makes the test even more high stakes than usual. Another disadvantage which applies to all these approaches is that none of them offer transferability to other jurisdictions, although studies, including one recently done in New York, show that that has not been as attractive to new lawyers as usual. I want to finish up here by mentioning a story that's often told in decision-making seminars about making decisions under unusual circumstances. There's a cardinal principle among firefighters that you should never drop your equipment. You must always hold on to your equipment. But there was one unfortunate circumstance in which a group of firefighters were fighting a forest fire. They were at the bottom of a hill and the fire was rapidly closing in on them from behind. So they began running up the hill. Most of them kept their equipment because they had been told never to drop their equipment. One realized that this was an extraordinary time and it was time to drop the equipment. He was the only one who made it. successfully to the top of the hill. So that's just a thought about how when you reach extraordinary times, sometimes we need to drop our usual standards and think about what will work best in this circumstance. Thank you.
Thanks, Deborah. We have a question that is relevant to what you've just been sharing. So I'll go ahead and ask you this as a follow-up before we move on. Any word if states will accept the portability of an online UBE score?
There is no online UBE. The exam that will be offered in October online is a half of the UBE. And so that NCBE is not going to validate as a UBE exam. Now, states can make their own arrangements. I have heard, for example, just this morning that both DC and Maryland are working on a deal that they will recognize one another's results, so that if you take that half UBE in either state, either jurisdiction, you would be recognized in the other. And the same is possible with these other approaches. Utah, for example, is only licensing people for Utah practice, but Nevada could decide to accept what Utah has done and transfer that admission if they wanted to.
All right, thank you. So Dean Billick and I are deans of law schools in New York, and over the last several weeks, we've had a number of conversations with every one of the other deans in New York and a couple in New Jersey. Everybody very concerned about this issue. Dean Billick, do you want to share with us how New York's law students are responding and how the law schools are responding to this crisis around the bar exam?
Okay. Thanks, Craig. I think I'm going to try to do kind of a chronology because this has been a really moving target. And I think I'll start on March 27th when the New York Board of Law Examiners, the Court of Appeals announced that the bar exam would not be administered in July on the 28th and the 29th. On March 31st, they announced that it would be, well, March 27th and March 31st is we're gonna give the exam on September 9th and September 10th. On April 1st, Craig and I and the 13 other New York deans and 2 New Jersey deans met several times and worked on a letter to the court laying out the costs of what the court proposed to do and the uncertainty about whether the exam would happen, and urging the court to consider extending a supervised practice order so that the graduates of the law schools could get out there and do the work and supervise under practice. And if the period became extended for a long enough time, to allow those graduates with kind of an affidavit from their supervisor that they were practicing law competently to be admitted without taking a bar exam. On April 3rd, students from all 15 law schools in New York State sent the Chief Judge D. Fiore a petition, incredibly well-written, well-researched petition, enumerating the costs to law graduates, starting with just making sure the court understood how much average indebtedness our law graduates have. And in New York State, it's between $93,000 and $168,000. Is that $172,000, depending on which law school you went to, including talking about how much it would cost just to extend the study period an additional month and pay for rent, depending on where you lived in New York State. Talking as well about the employment uncertainty, the toll on students' physical and mental health, the effects of denying this class of graduates the opportunity to serve clients who needed them more now than ever during COVID. And then they urged the court to adopt a diploma privilege plus. Their particular proposal was that the graduates of New York law schools be permitted to practice under supervision and at the same time complete online courses or exams that the state develops Both the MPRE and the New York Law Exam would be models for that. An affidavit from their employer that the candidate possesses the knowledge and skills to practice law, the completion of any CLE programs that the court or the board wanted to designate, and maybe the completion of some specified lessons that come from an organization called Computer Assistant Law Instruction, which also permit for, require the takers to do quizzes. So they were urging a universal system of provisional temporary authorization to be supplemented by some online learning and proof of learning, and then admission for the class. That came on April 3rd. I'm looking for number 4 here. On April 9th, there was an announcement that the court had appointed Judge Michael Garcia to chair a task force to look at and evaluate solutions that the court might have to employ in case of persisting public health concerns not permitting the bar exam to go forward. On April 28th, the court issued an order extending a temporary authorization for law graduates to engage in the limited practice of law under supervision for a period of up to 3 years if the bar exam isn't administered. On June 17th, so once the bar, it was announced that the bar exam was going to be offered on September 9th and 10th. Then what happened was the court needed to figure out places to offer it. So all of the law schools in the state were asked to find space in their building to offer the exam to their first-time taker grads of the class of 2020, which caused the deans to urge the court to consider what would happen to the LLM students and to retakers. It also caused members of the Board of Law Examiners to visit law schools across the state to see if, in fact, their facilities would be adequate. Understand that in order for the bar exam to be administered, so they need to get into the building the night before the first day and really take over any building the exam is being offered in for the first day, the night in between, and the second day, which would mean, excluding our other students. Most of the law schools stepped up, although some law schools were very concerned, law schools in particular with LLM programs were very concerned about the failure, what they thought would be a failure to accommodate the LLM students. Other law schools were concerned about retakers. Long story short, there's been a lot of looking at sites all across New York. My understanding is that, in fact, 2 of the law schools have procured the Javits Center. So the exam that was not going to happen at the Javits Center will, for the graduates of those 2 law schools. The board has been permitting applicants to register in waves. And the waves now include, the first wave was just the graduates of New York law schools who have, from the class of 2020, who have not yet taken the bar exam. I think the second wave was, I might get these 2 out of order, but LLMs. The third wave is graduates of law schools from other states who want to take the New York law exam. And just yesterday, they opened a registration period for retakers. Not promising that they would be able to sit, but giving them an opportunity to register in case there is space for them to sit. As this was all, let me see if there's any other important dates. So the deans recently met, and on June 15th sent the court a letter asking them to consider moving to the October online exam instead of September. And asking them again to make space for retakers who hadn't yet been included. Retakers happened. We have not heard yet back from the court about the June 15th about the October online, our request for them to reconsider the October online exam. There have been some good dialogues between Judge Garcia and the deans, where I think the deans were alerted to some of the concerns and perspectives of the court, and where I think Judge Garcia learned some about the concerns and the perspectives of the deans and their students. I will say that in the middle of all this, kind of as this was rolling out, there was a moment when students were trying to figure out, should they register for the UBE in another state and go there? Because they didn't know what New York was going to do, particularly retakers. And that was at a period in time when some states were making you quarantine, right? So they were thinking they'd have to go 2 weeks early and they'd have to go in a motel, and they, you know, some of that has sorted itself out. But none of my students are convinced that the exam's going to happen. And so the issues, and I guess the concerns raised by my students, which is part of our students, just part of Craig's question, you know, they don't hit all students equally. If what happened on March 31st, when you're 17th, when you left your law school, is you went back home to your parents' house. And, you know, it's a house where your own room is the way you left it when you graduated from high school. And all you have to do is, you know, move the yearbook off the desk and set up a study space. That's a really different situation than for our graduates who are living in Elmhurst, Queens, who have 2 or 3 roommates, who have not very good internet, or our graduates who live in Brooklyn or Flushing, who have kids running around underneath their feet, so we see, at least at my school, a real disparate impact of this way to handle this circumstances depending on the economic conditions of our students. They are scared about taking the bar exam. They think that anybody who spent 3 years going to law school and is in debt for $140,000, $160,000, if they are starting to feel sick on the morning of the bar exam, they don't have any confidence that that student is not going to walk in that room. They don't have any confidence that people who have been exposed are going to voluntarily say, well, for the good of those other takers, I'm not going to try to take this exam. I'm going to forego for another 4 months my opportunity to either serve clients or earn income as a lawyer. They are, you know, they're concerned about other things that people might think trifling, but wearing a mask for the full day, both days, is not nothing and not possible for students with asthma. The ones who have immunocompromised systems themselves are very concerned. The ones who are living with and caring for people who are at high risk are very concerned. And so the effect of this for those students has put them in a group of people based on, you know, some medical accommodation needs, but also some other real needs, put them in a position of deciding not to take the exam. I think, you know, when Washington State went to the diploma privilege, one of the arguments that was made was an equity argument. And I guess in this moment, I'm going to take this opportunity to say that I would really want to applaud Justice DiFiore for establishing a task force for the evaluation of institutional racism. And to note that it's really important to look at whether or not there is institutional racism that exists in this method of delivering this bar exam at this moment. Clearly, the most important function of any licensing mechanism is to protect future clients. And no licensing mechanism is perfect. Some are better than others at eliminating both false positives and false negatives. Almost everybody would agree that there are more perfect measures than the current bar exam at separating out those who have the knowledge, skills, and values to practice law competently. We just think they're way too expensive. We see it in the medical field where doctors do 20, 30 surgeries before they're allowed to, and then have a rounds reflection period before they're allowed to operate on someone themselves. We can identify supervised practice, simulated client interviews, observations of trial practice, internships of the type of medical practice as more perfect ways to decide how to license people before we let them loose on clients. But we know that those feel too hard, too expensive. So we have made the choice, a choice to use a reliable licensing system, which is our bar exam. So that was a choice that was made after weighing costs and benefits. The best device after weighing the costs and benefits to sort those who might harm clients from those who might not. By any analysis, the current pandemic with all its dangers and its unknowns has added significantly to the costs of an in-person exam. I think, you know, we're in a position, what my students are saying to me is make sure they understand the costs. And then finally, I'll just say the bar exam was instituted and became widespread to create more access to the profession. It was a time when everybody entered the profession by doing supervised internships with some lawyer who adopted them and took them under their wing. The bar exam was to be a source of equity, a leveling of the playing field to create opportunities for those who did not have someone who would mentor them through an internship. And maybe they did not have someone because they weren't kin to them, they weren't the same color as them, they weren't the same ethnicity as them, they came from a different class. We are at a moment when we know that moving forward with an in-person bar exam in September rather than July will have a disparate impact on those graduates who are poorer, who are not white, and who are physically vulnerable. The pandemic itself has magnified our underlying health and economic disparities. I wonder if this is the right moment when we're finally waking up to what equity means to go ahead with the status quo without reevaluating the costs.
All right, thank you, Dean Billick. One follow-up. Do we know at this point where the exam in New York will be administered? I know that there were, all the law schools were submitting information about our space availability. I understand some of the spaces that were offered up by law schools were not conducive to administering the exam for various reasons, the size, ability to control the space and so forth, but I have not seen a list of places where it will be administered. And we actually here in Syracuse plan to secure space at the On Center, which is our convention center here, for our contribution of space, but we've not yet gotten confirmation about that. Do you know where the court is in that process, or the Board of Law Examiners?
No, I don't. I mean, I know that a number of people who have volunteered spaces have been told those spaces are inadequate. Others have been told by preliminary evaluation that their spaces are adequate, but we don't yet have like a fully worked out agreement. You know, like they haven't told us, we haven't talked through the issues of security and other things, and who's gonna do that, take account of that. I know that there are some law schools that have found sites other than their own buildings to accommodate their graduates. And I know of at least one site, if we were physically in the space, we would be in one site where students who need accommodations are going to be accommodated. But there isn't a list.
Okay. Hank Greenberg, as you just recently completed your term as president of the New York State Bar Association. I can tell your shoulders look like they're a little higher. You had a tremendous year, did a great number of things. In that role, you sit at the juncture of the bar, the practicing bar, the courts, and legal education. What is your 30,000-foot view of how this has played out? Are you happy, satisfied with the response of the court, with the Board of Law Examiners' response? What kinds of challenges do you see ahead over the next several months? And then, what are your broader thoughts about this whole idea of reform of our bar licensing process?
So I will strike a slightly more optimistic tone than our prior speakers, at least about the prospects for the September exam. And the short answer to your question is, I think Chief Judge DiFiore and Judge Garcia, in an extraordinarily challenging situation, have done as good a job as would have been possible. And have really done magnificent work given all of the issues and challenges. One thing I think that's very important to note at the outset when we talk about New York, and particularly in light of Professor Merritt's, I think, excellent survey of what's going on around the rest of the country. New York is different than the rest of the country in a lot of ways. And the legal profession as practiced in New York is notably different than the rest of the country in a lot of ways. New York is exceptional for, among other reasons, because we have more admitted attorneys than any other state in the nation. We have over 300,000, I repeat, 300,000 admitted attorneys. Over 180,000 practice in New York State, are resident in New York State. In fact, California and New York represent, as admitted attorneys, 1 out of every 4 admitted attorneys in the entire country. But no state has as many admitted lawyers as New York. Why? Well, New York is the lawyer capital of the nation, if not the world. New York has the highest concentration of high caliber, talented, committed lawyers than any other state in the nation. New York law is the gold standard, I would submit, for the world. Lawyers all throughout America, all throughout the world want the New York bar credential. So we'll talk a little bit more in a moment, but when we hear about Wisconsin or Utah having diploma privileges, keep in mind, those are states where probably don't admit more than 1,000 lawyers a year, all year. In New York, traditionally, the July bar exam is taken by more than 10,000 law students. So we can talk about what other states are doing, but just keep in mind to administer a bar exam in New York is far more challenging logistically, involves far more people, far more proctors, far more venues than any other state in the nation. So I think Chief Judge DiFiore and Judge Garcia have done an extraordinary job recognizing that they were presented with a situation that also involved in March and April, when most of the significant decisions were made about the September exam, New York was the epicenter of COVID-19, the absolute epicenter. New York City had more confirmed cases, more reported daily deaths than any other city in the nation. Now let's fast forward to where we are today, June 18th. Thankfully, thank God, thanks to the extraordinary leadership of Governor Cuomo, New York now has the lowest infection rate in the nation. And that's thanks to the extraordinary leadership of our state government, the extraordinary dedication and devotion of the public that voluntarily complied with a shut-in order, so that when we were having this conversation in March and April, we were all cloistered in our homes. Today, and I'm speaking from Albany, New York, I'm in my law office. Now, keep in mind, we have very strict, like all offices that have opened in those regions of the state that are in what we call in New York phase 2 or phase 3. We have very strict standards and requirements to actually be in our workspace. But where we are today as a state on June 18th, thankfully, is a much brighter situation than where we were on March 22, Sunday at 8 p.m., when Governor Cuomo's New York Pause executive order went into place, and we all, were forced to be cloistered in our homes. No class, a graduating class of law students, has experienced more stress, greater crises, or struggle than the class of 2020. I suppose maybe we could talk about the law school classes of during the Vietnam War era or the World War II era that had their own sort of struggles. But the class of 2020 is experiencing sort of a perfect storm of bad news. The economy is now at Depression era levels of unemployment. Many graduating law students had job offers that have been rescinded. The job market is grim. That is awful. The uncertainty of when they will take the bar exam, if they will be able to take it in September, that is awful. Law school debt, in many cases, undergraduate and law school debt mounting over a couple $100,000, if not more, for the class of 2020 is awful. And the two things, I'm not so old that I don't remember what I thought about when I was a rising graduating law student. I thought about getting a job and I thought about taking the bar exam, and the class of 2020 is just living with that uncertainty, and it is beyond awful. And Dean Billick and Dean Boyes and the other 13 deans of New York's law schools have been magnificent advocates for the law students at every turn and every day, urging leaders, the Court of Appeals, Chief Judge Fiore, Judge Garcia, to do everything possible to sort of address those concerns and those uncertainties. And I applaud them for your advocacy and for your passion. I think you've done a magnificent job. The challenge for policymakers, though, in this case, and decision makers, is that they have to balance a variety of concerns, not only the despair that the law students are facing, but also keeping in mind the enormous number of people that want to be New York admitted lawyers. So at the very outset, for those states that have sort of said diploma privileges work for them, well, if we said diploma privileges work for the graduating class of law students in every ABA admitted law school, well, we would have 40,000 new admitted New York lawyers. And that, I think, for multiple reasons, is a bad outcome in a bad scenario, and why diploma privileges don't really, at least the diploma privileges is described as, I graduated from an ABA admitted school, let me into New York, doesn't really work. But let's just spend a moment about where we are today. And the New York State Bar Association, when I was president, was deeply active in this issue. We had an emergency task force on the bar exam, which included, by the way, Judge Garcia as a member, that came up with a set of recommendations that were adopted by the Court of Appeals within 42 hours that basically provide the framework for where we sit today. One was that the bar exam should be canceled in July, which it was, and it should be taken at or around Labor Day. So now it'll be taken on September 9 or 10 in New York. My best information, and I think it's relatively current, is that the Board of Law Examiners is not only working hard, but having considerable success identifying venues where the exam can be taken, assuming the trajectory of COVID-19 in New York in the fall is proceeding at or about the same lines that they are today on June 18th. If they are, I think we can be optimistic about the prospect of the exam being taken in September 9 and 10 with physical distancing rules in a safe and secure manner. And I believe the Board of Law Examiners are optimistic that that will happen. There's a lot of unknowns. We didn't know in March where we would be today. There's talk of second waves. So hopefully at or about Labor Day, like I said, New York will be in a place, New York City law offices are going to begin to open up next week. Hopefully that reopening process across the state, phased in, carefully evaluated by the governor and the health department on a daily, if not hourly basis, proceeds on track. So the exam optimistically will be held on the 9th and 10th. Fingers and toes crossed, but it's looking that way. It appears as though there will be as many as 20 separate venues that will allow for physical distancing across the state. So that appears to be good news. At the same time, the court system has adopted in New York practice orders to address those students who will not be able to take the exam, assume the exam can't be taken in September 9th and 10th. I think Dean Billick indicated it now appears as though every student from every law school in New York and across the country, a graduating student in the class of 2020, will be able to take the exam on September 9th or 10th in New York. As Dean Billick also mentioned yesterday, the Board of Law Examiners opened up their process to LLM students. That's more good news. So unfortunately, second-time test takers are not going to be able to take the exam on September 9 and 10. But it does appear as though the vast majority of students who would otherwise take the July exam will be able to take the exam in September 9 or 10. If they can't, if the exam can't be administered, then the Court of Appeals is allowed for practice orders, which means that graduating law students under the supervision of a New York attorney will be able to practice certain forms of law, and provided that they take and pass the bar exam by the end of 2021. So that means there will be at least three, it appears as though 3 opportunities for them to take the bar exam. September 9th or 10th, if for some reason that's not possible, then the February bar exam in 2021, and if for some reason or other that's not possible, if they can pass the bar exam in July of 2021, then under these practice orders, they will be fully admitted attorneys. One last word of comment about online testing. I spoke a little bit about diploma privileges. The New York State Bar Association's position has been, it's my understanding this is where the Court of Appeals is today, diploma privileges don't work in New York. I talked a little bit about the enormous number of attorneys that would seek those privileges. We all care, we all empathize with the plight of law students, but policymakers also have to protect the public from unqualified practitioners. They also have to pay heed to the respect that the profession has for lawyers and the competence of newly admitted lawyers. Wholesale diploma privileges just seem like the bad strategy in New York. And in terms of online testing, again, we're talking about as many as 10,000 people. How does one administer in New York by September 9 or 10 an online exam without proctors? How does one ensure the safety and security of the exam? How does one make certain that people who take the exam aren't looking at a book, aren't texting someone while they're taking the exam without proctors? The other thing I would sort of mention is if we focus the energy of the Board of Law Examiners today on online, and keep in mind, this is not a large state agency. It has limited resources and capacity. If we ask them to start focusing on how they would administer an online exam, that will take their eye off the ball of administering an exam in September for as many students as possible. So again, enormous praise to the deans of New York's law school who have been passionate advocates, and enormous praise as well to our policymakers, Chief Judge DiFiore, Judge Garcia, and the Court of Appeals for doing the best that they possibly can hope to do under extraordinarily challenging circumstances.
Thank you, Hank. I particularly appreciate your comments regarding online. If you know anything about Syracuse, you know we are big advocates of online as part of the education for JDs. It strikes me, yes, the New York Board of Law Examiners is a small agency, but it seems to me that the National Conference of Bar Examiners should be the ones looking at how to deliver a bar exam online. It is complicated, it's difficult, but I can tell you that, you know, as a law school that by choice before COVID-19 engaged an online system, it's possible to do remote proctoring. It's possible to deal with all of the issues that you described. I think the NCB is probably much better resource to be able to explore that. And from my perspective, I think that's exactly what we ought to be thinking about as we look forward. You know, the law school admissions test is moving towards online, AC, ACT, SAT. No reason why our exam, if we continue to have an exam, and of course that's a question we can debate as well, should not be available online for just these kinds of contingencies. So Anne Lefevre, you've been very patiently waiting while others have been talking. As a hiring partner of a major firm, this has a huge impact on you. Law firms generally look after the July bar in particular to those who have passed as the newest lawyers in their firms. And this has thrown a bit of a wrench into the works. From your perspective, what is the impact of this confusion and uncertainty around the bar exam? Although a lot of the uncertainty is being clarified, but how is this going to impact you, your hiring, Is it even a problem given the economic impact of COVID-19? Perhaps law firms are now contracting in a way that does not make this so big an issue. Can you share your thoughts about these things?
Thank you, Dean Boyce. Absolutely. One of the things that has actually, the delay in the bar exam has actually, I think, mitigated some of the issues for law firms, just because the predominant approach, and I'm speaking here really limited to the larger scale law firms, the more national law firms, has been to delay the start date. Typically, first years come in September, October, November. And the predominant approach among the law firms in response to COVID has been to push those start dates out, in most cases to January 2021, in some cases February as well. There's definitely precedent for doing this. It's the same response that a lot of firms took back in 2009 with the Great Recession. As in 2009, there are a handful of firms that have kept their start date the same or only pushed it back a few weeks. So they may have a bigger issue with the deferral, the delay in the bar exam. So far, we're not seeing, there's been some rescission of offers, absolutely, nationwide, but we're not seeing, in my opinion, layoffs of first-year incoming associates, rescission of offers on the same scale that it happened back in 2009, 2010. My own view is that I think that maybe because some law firms experienced or perceived that they experienced a significant backlash with the layoffs last time around. And so I think there may be a perception that the reputational damage from doing deferrals is less among law students in their recruiting abilities, their stature on campuses, than the repercussion if you do deferral of start dates. So just as a practical matter, deferral of start dates obviously affects compensation, and I feel nothing but empathy for the graduates who are, coming out of school with hundreds of thousands of dollars in debt, and we're expecting to earn a pretty hefty salary starting in the fall, and now that's not happening. So the law firms are showing sensitivity to that. Many are offering stipends for the deferred period. As far as I know, most law firms have paid out the bar exam stipend that typically happens in accordance with the regular schedule, even though the bar exam is pushed back. Some firms have chosen to go the route of cash advances for the fall period. In terms of what firms are actually doing in terms of the bar exam and in the different jurisdictions, a lot of the firms in the jurisdictions where Professor Merritt explained that the exam is indeed being pushed off, a lot of firms in those states are encouraging their incoming first years to write the bar in another state where it's going forward. They're also proposing this to people that don't make it in the September round, even where it's being deferred, and instead are going to be pushed to February. So a lot of firms are encouraging their incoming first years to go to another state and then apply to have the result transferred to the state in which they'll be practicing. And they're doing the encouragement by offering to cover the expenses that the incoming first years are going to incur if they go that route. And I've seen a couple of law firms as well for students who might find themselves facing a February bar exam, guaranteeing paid time off in the month of February to accommodate the situation. Obviously, the bar exam is not the only thing being deferred here. There's also going to be issues with the admissions process and a backlog there when the courts start to reopen. I have not seeing in the data that I've gathered a huge impact that is having on law firms in terms of changes in their practices. And I suspect, again, this is just my opinion, it may be because of the orders that are being introduced that are expanding the circumstances under which students can work under the supervision of other attorneys. So it could be that law firms just don't see that as a practical issue. The other thing that firms are doing is, or that people are wondering is, let's assume that things go forward and the vast majority of firms that are starting their students in January of 2021, will that be in person if firms are back up and running on their feet in the jurisdictions where people are still working remotely, or will it be remote? And the short answer there is that nobody really knows yet, because nobody knows what the world is going to look like next week, much less in January. So I think what will inform firms' decisions on that front is what their experience turns out to be with the summer programs, the class of 2021, which is either has or is shortly going to be starting their own summer programs. And the statistics there nationwide are showing that the vast majority of the summer programs, the dates have been shortened significantly. Most programs run around 10 weeks, and most programs now have been shortened to 5 to 6 weeks. Some have gone as short as 2 weeks, some have canceled them altogether. But I think that will inform how the first year class is treated. And also all those summer programs, again, the vast majority, I think it's 65% nationwide and significantly higher in the more hardly hit jurisdictions. Those programs are all remote. Again, as I'm talking about the summer class, the class of 2021, because the class of 2020 isn't the only one that will be impacted here. So some of the firms are saying, the ones that have canceled the program, a lot of them have said, we're canceling your program, some form of compensation is usually provided, but we guarantee you an offer in the incoming first year class of 2021. I'm only aware of one firm that has canceled their program and had not made that offer of a guaranteed offer. And a lot of the firms that are going forward with some sort of truncated version of a summer program, what they're saying, Pillsbury included, is it's business as usual. So we'll do the same thing we've done in past years, notwithstanding the current crisis, in terms of a summer program, summer associate position being turned into an offer to come back as a first year. We're going to do the same thing that we've done in all our past years.
That's very helpful. Do you have a sense, or any of the other panelists have a sense of what will happen to the roughly 85–90% of grads who don't go to firms that hire them before they've taken the bar exam? This, as you pointed out, is a very difficult situation. It's hard enough when you've got a firm that has made an offer and is hiring you and is paying you while you're taking the bar, but a huge number of students don't. Deborah.
Yeah, I do want to speak to that. Less than 20% of law graduates go to firms of 100 lawyers or more. And an even smaller percentage go to the very big firms that may be most able to offer these programs. The prosecutors' offices, the public defenders, the legal aid offices, the small law firms are not going to be paying people to take the month of February off to study for the exam. In fact, most of those offices have people doing client work immediately. I teach both a prosecution clinic and a defense clinic. And so I have students actually who've gone to New York from Ohio to do both of those things. And they begin doing direct client representation right from maybe the third week. They have 2 weeks maybe of boot camp. So these are not solutions for the vast majority of people who are being admitted to the bar in either New York or elsewhere. And I think we really have to think about our commitment to access to justice when we're thinking about how to design these things. The practice orders are sort of ironic because they are actually a temporary diploma privilege. Most of these practice orders, depends on what the particular division in New York does, but they allow people to go even into the courtroom without their supervisor with them. They check in with the supervisor from time to time, and people do a wonderful job. It's not a problem. But to then ask these people who are actually actively defending clients or representing people in employment discrimination cases in January to drop those clients in order to study for 8 weeks to take a bar exam just strikes me as kind of confused. I understand all the problems that New York is facing and other states are facing, but I just don't see that as a solution. I really think we need to remember the 80%.
I think if I can just respond to that, I think it's an excellent point. The perspective that I have and that I see is obviously big firms have the luxury of doing what a lot of these firms are doing. So it's an excellent point and affects a fraction of the graduating class.
Dean Billick?
So I actually have a question, I guess primarily for Hank and Anne, who are currently, Hank, you have some time to practice law, don't you? Or do you give all your talents to the state for the good of the people?
Well, I'm starting to practice law more actively now.
Okay, so, and this is a genuine question because it is entirely possible that I have a blind spot here. But if you had somebody working at your firm who you were on a case with, supervising for 18 months and the bar exam was delayed that long, and this was a person who'd been preparing memos for you and I don't know, doing the document review and maybe going with you to court and those kinds of things. I guess it's a two-part question. One, would you need the bar exam to know whether they were competent to practice? Would it add anything to know that they'd passed the bar exam? And two, do you really want to give them 2 months off to study if they've turned out to be a valuable associate?
And that's a question that was also in the Q&A, a version of it in the Q&A. Hank, so you're on the hot seat here. And let me just throw another one in while you're thinking about that.
Here we are in the midst of COVID-19, and it sounds like we're about to engage in a debate about the value of the bar exam as a mechanism for assessing the competence of attorneys. Now I'm going to share my own personal view. If someone took the old New York bar exam and we were talking about New York litigation or a case, I would have a much greater confidence that they had a clue about what the CPLR was an acronym for than I would if they merely graduated even from a New York law school today and took the UBE. I'd have to tell them civil practice, law, and rules. But that's another conversation, right? UBA versus the old bar exam. Your question, Dean, so much of this discussion depends on what your perspective and point of view is. Deans of law schools have a constituency. They're called law students, about whom you are passionate and rightly so advocates for. Attorneys and law firms, if I'm working with a lawyer on a case and you ask me if they're deeply involved in the case and performing a really valuable role, although if we're talking about a first-year associate, 6, 7, 8 months into their first year position, that's very different than a 5th or a 6th or a 7th year associate in terms of their professional development. Would I want to lose them to study for the bar exam if they were playing an integral role 18 months into it? The short answer is no, of course not. I'd want them to continue to work on the case. And then there's the systemic question about how do policymakers, knowing how many people want to be New York admitted lawyers, and understanding that not all law schools are created the same, not law schools, all the nearly 200 plus law schools around the country, don't all provide exactly the same kind of education. So as a general proposition, I think the bar exam continues to make sense. And I think COVID-19 does not provide a particularly excellent vehicle for us to have, a debate about whether we should or we shouldn't have it, or make those kind of decisions as we're all trying to manage a crisis.
So I just want to say my constituency is the future clients of my students. So I know you assume maybe it's both, but I just want to I think law schools have an obligation to future clients. And the only way I think it's relevant, Hank, is because I think it's always a cost-benefit analysis, what the best licensing mechanism is. But I take your point. It's maybe not fair to shift the conversation to whether we should have a bar exam at all.
If I could just follow up, Hank, diploma privilege, if it applied only to graduates of New York law schools, with which the Board of Law Examiners is quite familiar, I think.
If we were talking about the old bar exam, that might be interesting. If I knew that New York's law schools were teaching New York law as they once did. But the perfect truth is, even since the UBE, the data that I've seen Makes it very, very clear that New York's law schools are no longer, at least on the whole and by and large, teaching very much New York law. So the idea, and here's the other point too, about New York law. Not all law is created equal. And of course, the UBE teaches the law of nowhere, right? Not a particular state, but general principles of law. Just take civil procedure, right? Law students who graduate from New York's law schools, like the other 49 states, right, are largely taught civil procedure in terms of the federal rules of civil procedure. They're not taught the CPLR, and people aren't taking New York practice on the whole and by and large in New York's law schools anymore. So I no longer have very much confidence that graduates of New York law schools know a whole lot about New York law. That's, by the way, that's not to suggest they don't know a lot about a lot of legal principles, but we're talking, your question is about diploma privileges. So, you know, taking all 3,000 plus graduating law students from New York's 15 law schools and saying without any test at all, you're now New York lawyers. I don't think that's a prudent decision. And I don't think it's terribly fair to all those people who took the bar exam and didn't pass it the first time and now have to take it a second time. Right. So
when you talk about New York law, Hank, are you talking about essentially one course, the CPLR, Civil Procedure Law and Rules? Because that's a very small percentage. If it's one, and I know that's a course that's not taught in some law schools in New York. Students didn't enroll in it, I think, is for one of the reasons. But that's a small part of the 90 credit hours overall. Where else do you see a potential deficiency there?
Well, at least when I graduated law school in the late 1980s, actually most of my professors would point out differences in the course of assuming we're not talking about like federal tax, right? But your basic common law subjects, most of my law professors, if there was a significant difference between New York law and general standard principles, would point that out in the classroom. So the idea of being given a well-rounded education about New York law when you graduated from a New York law school was a meaningful thing. And by the way, let's talk about Wisconsin, because Wisconsin's diploma privileges, I think, kind of makes my point. In Wisconsin, as I understand it, diploma privileges are extended to only 2 law schools, the University of Wisconsin Law School and Marquette. Why? Because the Board of Law Examiners in Wisconsin understands that the graduates of those law schools are steeped or at least taught something about Wisconsin law.
I think those are the only 2 law schools in Wisconsin, I believe.
That's right.
But
only 2, as I understand it, that have diploma privileges.
I want to get to a couple questions, if we could, that are specific coming from the Q&A before we run out of time. I know we could discuss the bar exam, but just any of the panelists can answer these 2 things. One is that there was, right after the lockdown, the Appellate Division, First Department Character and Fitness Office was unable to process applications for some time. And so now there's a current process of submitting applications electronically with virtual interviews and admissions. Does anybody have knowledge about the impact of and where the backlog is right now? How much of that has been recovered? Okay.
Similar. I can confirm that most of what's in that question is true, that there is a backlog.
Yeah. Another question. Any advocacy discussion in New York around making fees refundable if students who are registering in June are not seated? Right now, these students are charged non-refundable fees, not only for non-guaranteed seats, but also for laptop registration, et cetera, before they know if they have seats. So if you heard anything about that, I know I'm not aware of that, but.
No, but what I'd say is if they registered in June and the board is now taking applications from people who, you know, we're at the 3rd wave past the June. Oh, we're in June. This is somebody who's just registering now. No, I can't help, sorry.
Okay.
So, Craig, I don't know more than Mary Lou did on that, but I want to point to a broader problem with the fees, which is people talked about they're New York students. We have students in Ohio who take the New York bar. And when New York told them to go to other states, several of them went to DC because they thought they would get to take the UBE in DC and waive into New York. They've now paid fees in both New York and in DC, and are not going to get to take a uniform bar exam or waive into New York because DC has decided not to offer the uniform bar exam. When you have a chance, I'd love to tell Hank how much I agree with him on a couple of points. Could I do that for him?
Well, just one moment. I think we've had a couple of questions pop up about the New York law exam, Hank, as addressing the issue that you raised about grads not being familiar with New York law. Is that not a fix for your concerns?
So the current New York bar exam has a 50-question multiple choice open book test that the State Bar Association, our New York Bar Exam Task Force, reviewed and found it not at all either challenging to take and pass or in any way incentivizing New York's law schools to teach more New York law. So one of the recommendations of our task force was that part of the New York bar exam be retooled, be made more rigorous than it currently is.
All right. Any update on whether students from non-ABA accredited law schools, particularly those in Canada, will be able to apply or sit for the New York bar exam? Dean Billick, are they included in any of these waves?
You're muted, Mary Lou.
Questions magnify and amplify what Hank said. Because there is a lot that the court and the board are trying to figure out right now. And for the court, this is their side job, right? Their primary job is to administer justice in the state. So, but it's a very good question. I don't know the answer.
Okay. All right. Deborah, you want to go ahead and respond?
Yeah, I agree with Hank on two very important points. One is that state law and even local rules are more important than federal law. My study has shown that very strongly. And in fact, even NCBE's own study has shown that, one that they're releasing. And so we need to deal with that with the bar exam. We also need to deal with the fact that research is, after writing, the most important skill for new lawyers. And the uniform bar exam doesn't test that at all. So I agree with you entirely. And I think you'll be seeing more about that in coming months. The other thing I agree with you on is I would not do a diploma privilege in New York. First of all, you can't do it just for New York law schools. That violates the Dormant Commerce Clause, which is probably a question that appears on the uniform bar exam. So we shouldn't go there. What I would do is a series of things. I would start with first making a special rule for people who are doing public service. We actually have a piece, I have a piece co-authored with a few others coming out in Bloomberg Law tomorrow morning that will talk about creating a lawyer's justice corps and how those lawyers who do actually get good supervision, even in the usual course of things in legal aid and public defender and government offices, could be licensed based on several months, maybe even as much as a year of that service, rather than having to take the time off to take the bar exam in February. Another step from that would be to license people generally who have good supervised practice. If they've had several months of supervised practice, do they need to take off time from either of your firms? And then one final component one could think about there is, what about people who have done 15 credits worth of clinics or externships during law school? In other words, a full semester plus of that work. They will certainly have had, if they're in New York, exposure to the New York civil or criminal procedure rules. They will also have had the kind of experience that we know that new lawyers really need. So it's not really diploma, privilege, or exam. I think that actually these options, and any of these options, by the way, would coexist with the exam. It would greatly reduce the number of seats needed. And so, you know, LLMs who aren't able to get supervised practice or weren't eligible for clinics could still take the exam.
Deborah, how does Wisconsin avoid the Dormant Commerce Clause?
Wisconsin's privilege, as I have co-authored a piece that is out there, is unconstitutional as it currently stands. They were challenged a number of years ago. Judge Posner in the Seventh Circuit wrote an opinion in which he went, no, let's send this back for more factual development, and the parties settled. It is possible to create a constitutional diploma privilege limited to schools within the state, but it has to be very carefully tailored to special knowledge that the court has of the schools in that state, or the fact that they're teaching that state's law. Even then, you probably need to extend it to other schools, like take Seton Hall, for example, right across the river from Manhattan. They might teach as much New York law as Columbia does. So if you go to Bar COVID-19, our website, you will find all of our articles linked.
Couldn't you argue that just giving the diploma privilege to the public schools doesn't violate the Dormant Commerce Clause?
There is an argument.
I could get behind that one.
Right. I could too, Ohio State, right? There's an argument that satisfies the market exception. Hey, do we know our constitutional law or what?
Right, there's a question, Anne, about whether law firms have thought about providing scholarships for students that are not part of their incoming classes but are in financial need due to the effects of the pandemic. I gather generally providing assistance to law students generally.
Mm-hmm. I've not seen anything created. I'm not personally aware in response to COVID right now. I mean, obviously many law firms offer a lot of financial support and scholarships and stipends, but I haven't seen anything specifically linked to COVID.
All right, Dean Billick, would LLM graduates currently be able to sit for the exam in New York State? I think we may have answered this one, but
yes. Yes, if they register, and the fourth wave, they missed their wave if they haven't registered yet, and the fourth wave just opened yesterday. So I would leave the session and go online and register if you're an LLM candidate who wants to take the New York Bar Exam.
Okay. I have a question for you, Deborah. You mentioned at the outset research that reflects that the bar exam is not particularly predictive of success as a lawyer. Why is that? What kinds of things ought to be in a bar exam if we wanted to have one that was actually validated for law practice?
Well, I chose the word mediocre purposely. It doesn't fail. It might get a B or something like that. It certainly has some correlation. The biggest thing that's missing is any kind of assessment of ability to interact with clients. Particularly when we think that people worry about the bar exam, worry about solo practitioners. Solo practitioners interact with clients. So do all the people at the other 80%. Even within large law firms, we have found that people who do transactional work as opposed to litigation interact quite frequently with clients in their first year. In fact, one person explained that on any deal, you have a whole hierarchy of people. And so if there's somebody at the client and the lower end of the totem pole who has a question, they'll call the lawyer who's lowest on the totem pole. So lots of interaction with clients. And that's not just people skills, they're specific things. It actually overlaps a lot with professional responsibility as applied. How do you talk to a client? How do you really counsel them? How do you tell them about your duties with confidentiality? The other big one that's missing right now is research, right? I mean, the bar exam seems to be based on a notion that you come into the workplace with a measuring cup that's filled with knowledge, and then you're going to draw upon that cup and pour it on all your cases. But that's not how lawyers function. In fact, they rely almost never in the first year on memory. They check and recheck everything. And many of them practice in fields that are not tested at all on the bar exam, sometimes that they never even took in law school. So it's that ability to do research that really matters. So those are the two biggest holes. Yeah. There are some others that I could point to as well.
I think the first one also is probably directly related to the highest percentage of complaints that come in from people about their attorneys, is the interaction, the failure to communicate, and that kind of thing. So there's certainly a validating connection with the kinds of things that the court wants to protect the public from.
Absolutely. And when you think about, interactions with clients also means being able to get the facts that are important for resolving the matter. We asked people in our focus groups to talk about mistakes that they had made in their first year, or we also had groups with supervisors of new lawyers, mistakes that their new lawyers had made. And the mistakes often related to something having to do with client interaction. Somebody failed to get a key fact from the client. Somebody was unable to really counsel the client in a way that respected the client's autonomy while also giving the expert advice. Or somebody wasn't able to give bad news. We give bad news to clients a lot of times, and the new lawyer was ineffective at doing it. Or often that the new lawyer promised too much. The client thought that this hearing was going to go entirely in their favor, and it didn't. So, I mean, these are specific types of skills. It's on law schools too, right? We don't teach nearly enough client skills in law schools.
Did you have a comment, Anne?
I didn't. I agree with everything that Professor Merritt was.
I saw your hand. I just didn't want to.
Oh, sorry. No. I was nodding because I agree with a lot of those points that neither the bar exam nor law schools right now necessarily teach those. I mean, I wouldn't even call them, as the point Professor Merritt was saying, soft skills. They're real substantive skills too. So.
We only have 5 minutes left, so I'm going to give each of you a chance to close with a minute or so, and then we will be done. So let's begin with you, Anne. Put you on the spot.
No, I mean, this has been incredibly informative. It's fantastic to hear perspectives from academia and the people that are preparing the associates that we're fortunate to have join us. So again, I empathize with what the student bodies are going through, but the class of 2020 and the class of 2021. And I like to see certain law firms kind of trying to take creative approaches to how we can balance, the changes in our business needs with the pressure that these students are under. So it's been a pleasure to be with you all today.
Deborah?
So my pleasure as well. And, having agreed with Hank, I'm not sure what else I have to say here, right? But I think
maybe calling you for research on his.
That's right. Well, I think I may just actually finish by agreeing also with something Mary Lou said and what Anne embodies along with Hank, which is that, my constituency is future clients. I got into this work studying licensing and competency because of my own family's experiences as medical patients, and realizing that the quality of doctors just really affects us so deeply. And it made me feel that every student I see is going to touch so many lives, and I have to make sure that student is prepared to do the very best that our profession can do for those lives.
Dean Billick.
Good. I'm glad I don't have to go after Hank. So I just want to say that I really do believe that the Court of Appeals and the Board of Law Examiner are trying very hard to protect clients and figure out what's possible. And I don't have any doubt of that. I don't think this is some Machiavellian scheme to torture students. And I actually don't primarily come out of this. I care deeply about my students because I've seen them all practice for a full semester in an intensive clinical program, and they are ready to go. And I care for their future clients. And I care for my students because I'm a human being and I have empathy. But for me, this is really not about how extraordinarily emotionally hard this is for them. This isn't my sympathy for my students. It is, I think, a difference of opinion about whether the bar exam is enough of a benefit to be spending so much energy trying to figure out how to do it at this moment. And it is, for me, a question from where I sit, from my lens, the people who will not be able to afford this extended unlicensed period The students who come from the communities most exposed to the virus with the poorest access to healthcare and with the highest likelihood of having underlying conditions that make the virus more fatal are the people that the people in the street are trying to tell us to recognize that we're planning for a planet that those people don't inhabit, and that we have to start understanding the effects and the disparate impacts through a lens that's so different than ours that it's going to take a lot of work.
I have strong feelings about the need for revisiting the bar exam myself. And an example is the fact that I practiced tax law for almost 9 years before I went into academia. I took 3 different bars, Ohio, New York, and Missouri, and none of them had anything about tax law in them. So from that perspective, I spent 9 years of practice totally untested in terms of my competence to do that work. So I do think it's something, it's both overbroad and underbroad in terms of what it covers. And I think it's worth relooking at. But I'm going to give Hank the final word before we close.
Then just a couple of thoughts. First of all, my deepest gratitude to the New York City Bar Association and my fellow panelists for this fabulous discussion. I've learned a lot. And so many of the ideas, especially ones that have been generated by the deans in New York and Professor Merritt, description of what's going on in other states, I can't emphasize enough the fluidity of the time in which we now live. The die, I think, from a public policy point of view, is now cast for the September exam. I think that our Board of Law Examiners is plowing forward. They're going to do their best. They are doing their best to try to put that exam on September 9 or 10. But COVID-19 has puzzled and baffled us in so many different ways. Who's to say if the exam isn't administered in September? Because it can't be, right? If there is this second wave, God willing, there won't be. But if that exam can't be administered in September, then the class of 2020, what they're struggling with, what they're suffering with, would be worthy, I think, of another look in revisiting some of these issues and ideas that Dean Billick and Dean Boise and the other deans have sort of put forward, for sure. Because that's a different world. Who would have thought in February we'd be having this discussion today? So if in September, all of a sudden we're shut down again in New York, you know, I think everyone, Court of Appeals, the New York State Bar, the organized bar, law firms, all of us should be open to sort of figuring out how we deal with the justifiable concerns being raised by the class of 2020. I'm also left with this enormous sense of pride, frankly, in how our profession has grappled with this issue in New York. I could not be prouder of our deans, how conscientious they have been, how earnest they have been in percolating ideas and creativity. I could not be prouder of our court system, our chief judge, and the way they've dealt with that. I could not be prouder of how the organized bar has discussions like this sort of risen to the challenge. Really, really proud of New York State and how we really bent the curve. And now we're in a position where there's some cause for optimism. And I'm left with the thought, above all, the class of 2020, for those of you who are on this call, you need to know you are in all of our thoughts. Anne, representing sort of hiring partners in law firms, myself as a leader, or at least once was a leader of the organized bar as of a couple of weeks ago, our deans, Professor Merritt, you are foremost in our minds about trying to meet your needs right now and understand your challenges. And we are doing everything in our power collectively as a profession to try to do that.
Good words. Thank you, Hank. And thank you to the other 3 panelists as well. It's been a pleasure to talk with you today. I think we've shared some very helpful information with our audience. Thank you, audience, for joining us. And again, barcovid19.org is a place you can go to keep updated on developments around the country. So a little plug for Deborah's site there. Thanks so much and have a good afternoon.